This is Boadu TV. Truth and integrity.
And he blogs about things that are unfavorable to the government. Over the last 10 days, he has been arrested twice. All that kind of information Dominic Aini has. He told the press that he is yet to charge Kwabena Adu Boahen.
Boadu TV suni ye jinem gidi. Ewisia maye sama mu nyina kwa be. Na de ate ne say Attorney General Dominic Ayene wone eye Kwabena Adu Boahen. Abrante na mo susu se wo di sika ewia oman ni sika no. The case no enso how Paul Adom kire nye Kevitele no say by December na Paul ewo Kevitele Paul Adom kire afaya da fa ho afaya da fa ho pa na wone lawyer ya wo besi na pwana mu wo ne constituency no onu so be kasa da fa sesia Chief Justice petitions akọ omampanyin wo se onyina di Kevitele ba se osoro mame so be yi na di so onyina di lawyer ya kasa da fa ho na uye nu si nchen a Paul Adom kira fa ya da fa Okatakyie Afrifa Mesa 1 week ni ya che ni 2 times na yin so ya tache Okatakyie Afrifa Mesa na ni ti na yeyi omuja ne ntem enya sa nka obede mama ya che omuja ne ntem Paul Adom kire chese oye journalist munya no nyina dwuma munya no ondi musika ye onya appointment bia ye ondi Ghana sika ye eti adentina mo chichi ne rough airtime no ase mo pese mo intimidate no ono so akasa intimidation obi intimidate no Ghana Okatakyie na kasaka.
Ghana does not belong to the NDC, Ghana did not belong to the MPP, and Ghana would never belong to the CPP.
The only thing I can say about this is that I'm happy Kwesi Pratt didn't find opportunity and occasion to make this when Akufo-Addo was president. He didn't. Because it wasn't like that. Look at the vetting. Justice Sremsai, the Deputy Attorney General, he was awarded a scholarship by Akufo-Addo Scholarship Secretariat. His NDC leanings were completely known. Very, very well known. Yet, when he applied for scholarship, he was assessed on the basis of his academic capabilities. And he was awarded a scholarship by Kingsley Agyemang Scholarship Secretariat under Akufo-Addo. His name was there. Everyone knew he was an NDC person. But it didn't matter. And that's why I'm excited about Akufo-Addo all the time. For whatever it is. Kwesi Pratt was not able to make the statement so passionately when Akufo-Addo was president. Of course, even though he makes a statement now and he sort of uses the same brush to paint all governments and say every government must do the right thing, which I agree. But when Akufo-Addo was president, you can talk about Galamsey, which would have been legitimate. But you cannot make the statement that Ghana is for him and he's taking Ghana upon himself and a criminal gang has come to operate. Because some people, when they come into power, they truly behave like a criminal gang. It looks like that. For some people, it looks like that. They come and they are taking, they are beating ballot boxes, they are beating policemen. Then they take over and the minister says, I've sacked 5,000 people. That's what Kwesi Pratt is describing. And it is very serious. But the consolation is always that the pen will always be mightier than the sword in a democracy. And the people's power will always trump over dictatorship, oligarchy, partisanship, extreme partisanship. People's power will always trump over it. So we like what Kwesi Pratt is saying. Ambassador, good evening, sir. Today I'm on your side, though. Today I'm on your side because the things that you are speaking, only people with such wisdom and profound experience can speak that kind of thing. Today I'm fully on your side. Thank you, sir. Thank you, our father. Thank you for making this statement. Whilst Kwesi Pratt was talking, Okatakyie Afrifa was arrested this afternoon. For what? We don't know. For what? We don't know. He is not a government contractor. He is not a businessman who is evading taxes and doing his birthday at Independence Square and GRA is looking for him. He is a journalist, news reporter, presenter, blogger, whatever you want to call it. And he blogs about things that are unfavorable to the government. Over the last 10 days, he has been arrested twice by national security operatives. In one situation, he was arrested after, I believe that he's a part-time student at Gimpa, as many of us. So he had gone to Gimpa to take an exam, and he drove out of the place. And because he's in a class with people, everybody knew that Okatakyie has come, and this is the car park. And after that, he would turn this way. All the cars go the same way. The national security people were there, and they picked him up. They interrogated him. They left him. He came back on radio and continued on his blogging platform and continued to do what he's doing. This afternoon, just before the rain started here in Accra, we were told that Okatakyie Afrifa has been arrested. Lawyers are scrambling around this evening, talking to him and finding out how they can grant him bail. What is all that? What is all that? What is all that? But that's the news for you. That's a big story. So the two stories that came out just before we went into press, unpalatable. The first one we've dealt with the 3 petitions that Felix Kwakye Fosu says have been shipped from President Mohammed's desk to the Council of State. And then this arrest of Okatakyie Afrifa, the journalist type guy who is blogging on topics and themes that are unfavorable to the ruling government. That's what I had covered many attorney generals. I've never seen an attorney general make his case against the accused person without having charged the accused person in such an elaborate manner as Dr. Ayine did yesterday. I mean, by the time Dr. Ayine finished the press conference yesterday, it was clear in everybody's mind that Boadu Adu Boahen is a big thief. I thought that was unfortunate. That was a low point of our democracy. That was unbecoming of a distinguished minister for justice. I felt so sad because it is not about partisanship. It's about the pride of the democracy. It's about the pride of having systems that work. Many years ago, I traveled to Côte d'Ivoire in 2011 with Raymond Archer, the journalist, and we went to interview Laurent Gbagbo. We all felt very proud as Ghanaians. In fact, Kwesi Pratt led that team. We all felt very proud as Ghanaians when we were telling the Ivorians that in Ghana, we have so many radio stations. That time there had been an election that was conflicted. And we said in Ghana, this will never happen. The Electoral Commission will mention the results and that's it. And we felt very good about ourselves, that our democracy was ahead of the Ivorian democracy. Media plurality was ahead of the Ivory Coast media plurality. I remember Kwesi Pratt was shocked that, hey, they don't have a single private radio station since 2011. So there are things about our constitution and there are things about the conduct of our public officers that can make us proud, whether it's NDC or MPP. What happened at the press conference yesterday in relating to the cases? I thought, I appreciate Dominic Ayine saying that he only come to us with cases that he has investigated. But here he was talking about Solomon, that Solomon was running away from justice. And the next day, Solomon issues a press statement, almost suggesting that a learned minister for justice was lying. I mean, how? So I put here the face of the late Cor Swansea, so that it might give us some inspiration. You see, when you go to the Manchester United dressing room at the Old Trafford, you see the photographs of Dennis Law, of Sir Bobby Charlton, and it's supposed to inspire the new generation. I don't know whether in the dressing rooms of Kumasi, Asante Kotoko, they have Baba Yara, Infum Kofi Tufo, Kwesi Appiah, Opoku Afriye, Kofi Bedu, Francis Kumi, those old players that inspire. Whether House of Folk have the Fearsome Five, Samson Lamte, Peter Lamte, Ofe Ansan, Nana Benyi Krensel, Shamokwe, whether they have that. But these photographs are to inspire the new generation. So with a very heavy heart, I put out these photographs so that we might be inspired. And please beg Dominic Ayine that this is the history of attorney generals. Not all of them have been MPP. Not all of them have been CPP. Not all of them have been NDC. But they have all kept at least that very distinguished characterization of our attorney general, who does not offend the Latin maxim nemo judes in cosa sua. He doesn't offend the Latin maxim. And he doesn't offend the Latin maxim of hearing the other side. But for what's hear the other side? Hearing the other side. What's the Latin for it? Oh yeah, it's just escaped all of us. But a judge is not, you cannot be a judge in your own cause, and you always have to hear the other side. You should not be a judge in your own cause as nemo judes in cosa sua. And then hearing, you must always hear the other side. These attorney generals have all, as far as the record shows, have abided by that principle. Even when the quality grain trial was on, and I covered quality grain every day, and at the end of the process, journalists, including international journalists, will approach the Attorney General Nana Akufo Addo and say to him, how is the case going? And he always said the same thing. Auditorum pattern. And Nemojudes in Kosaswa. No Attorney General has made an attempt to violate these principles. Yesterday, I saw those principles buried on their head when I watched the press conference of Dr. Ayini. Attorney General Akufo Addo will tell the press during the trial of Quality Grain, they'll ask him that, do you think the accused persons are guilty? He'll tell them, no. We are going to make our case. We've continued to make our case. The defense will make their case. At the end of the day, Justice Afre will decide. And then he'll be smiling. And then he goes away. They ask him that, do you think the verdict? He said he should ask Justice Afre that. This was in the days of 2001. When everybody was excited about Kufuor's administration that they are going to catch some thieves and they are going to deal with some NDC thieves of 20 years old. Attorney General Akufo Addo resisted ever to comment on the process of the case. I remember I interviewed Dr. Obed Asamoah in the year 2000 after the very heavy Supreme Court case of the voter ID card. It was a big matter that sharply divided NDC and MPP. Obed Asamoah made his arguments in the Supreme Court forcefully. When he left the court, I rushed to him with a microphone and I said, Doc, how do you see the court? He asked me, how did you see it? And I said, well, I think it was good. Do you believe that the court will agree with you? Then he stopped. He was walking. He stopped. He said, these are not questions you should ask me. The Supreme Court panel has sat. They have heard me, and they have heard Nana Akufo-Addo, and they have heard Mr. Zuenis. They will make a decision. At 2 o'clock is what they said. Can't you wait for 2 o'clock? That's what he told me. And I was very excited by that. Betty Moldy-Drisu, when she was Attorney General, there was so much pressure on her that she should try people, she should convict people, she should try people and convict people. And sometimes she walk out of court and the media will ask, he says, no, please. She said that I have been a Solicitor General of the Attorney General's Department before I became Attorney General. We are not supposed to conduct our case in the press. We will not conduct our case in the press. And everybody used to remember that phrase, we will not conduct our case in the press. That was Betty Moldy-Drisu. Martin Amidu, hardly ever heard, speaking to journalists, Benjamin Kumbuo. And I'm using the NDC examples. And Dr. Ayeni was Deputy Attorney General to Marietta. Viewers, did you ever hear Marietta, ever, as Attorney General, trying any case publicly and telling people that this person is a thief and I'm coming after you? Civil servants, I'm coming. Attorney General and Minister for Justice threatens people that if you are like Justice Oduboahen, I'm coming after you. Anyway, for the purpose of the history, this is called Swansea. He was the first African Attorney General. The first Attorney General was not an African, even though it was after independence. His name is Godfrey Bain, a very distinguished Irish barrister, was our Attorney General then. But after him came called Swansea. This is Dr. Obed Asamoah. This is Nana Akufo-Addo. This is Papa Osuan Kuma. This is Ni Ayikwe Otu. This is Joe Gatti. And I remember Joe Gatti. Again, I covered the Quality Grain. Did I say Quality Grain? The MV Benjamin. The cocaine MV Benjamin trial. I covered it on a daily basis. Every day I was in Joe Gatti's office. Never once, whether when he set up the Georgian Wood Committee or when the trial started, did Joe Gatti ever grant any interview, even after the people had been charged. They had been charged though. They had been fully charged. The trial was on. Gatti never ever granted. And he always told the media that, what do you think? And he'll be joking with them. What do you also think? You're asking me. I'm not the judge. When they say the court is the judge. I'm the Attorney General and I'm doing my prosecution. And then he will smile about it and he will leave. Never once did Gatti do any such thing. If I roll it over this way, Gloria Kufu began the trial of Opuni. Did you ever hear anything? Godfrey Dame here. And somehow, I don't know whether Dominic Ayini has issues with Godfrey Dame. I understand from what happens in the Attorney General that he will ask that the Godfrey Dame step here, then he won't step there. That's not. We'll come to that. But I remember during the Atu Forsen trial, Atu Forsen was Minister of Finance today, when Godfrey Dame was Attorney General. NPP people were attacking Godfrey Dame that why did you allow Atu Forsen's statement to be taken in Parliament? He should come to a police station and take the statement. Who does he think he is? And Godfrey Dame told them that, but he's a member of Parliament of the minority. Parliament's a place where we can find him. So if you can find him in Parliament, what's the problem with it? They said, you have to go to his house. Dame said, for what? You should do that. Atu Forsen's statement was taken in Parliament, in the comfort of his parliamentary office. That's where his statement was taken. He was given a self-recognizance bill. That means he doesn't have to pay any money or put any money up. That's why Godfrey Dame did the Atu Forsen trial. The same Atu Forsen trial that became, they've forgotten, or they remember they will say it, Atu Forsen. The court people went to Parliament that he may make his statement. And then today, what do we see? Attorney General. Wow. This was something. Dr. Dominic, good evening to you, sir. This one was something. Attorney General finished trying the accused person, buried him. And as you heard in our promo, the only thing Dominic Ayine did not do about the press conference yesterday on Okatakyie Adu Boahen was that he was unable to pronounce a sentence. That's the only thing he couldn't do. And why couldn't he pronounce a sentence? Because as we said in the promo, trials are not conducted in the media. Anyway, end of that story. Now, let's come to the main one. So, Dominic Ayine yesterday said that Okatakyie Adu Boahen had stolen money. He had diverted, but he gave all the details of the investigation. He had bought 27 houses at 295,000 cedis at the same day. He had taken money that belongs to the National Signals Bureau and he had used it upon himself. He and his wife, they had misappropriated 39 million cedis and $7 million. All kinds of allegations were mentioned yesterday. With all that kind of information Dominic Ayine has, he told the press that he is yet to charge Okatakyie Adu Boahen. He has not charged him. Whether for stealing, for fraud, defrauding by false pretenses, causing financial loss to the state. No charges had been preferred against the accused person. No charges. With such comprehensive, what looked like a comprehensive investigative report, the Attorney General, who was holding this comprehensive investigative report where he knows how the guy bought a ticket and changed his ticket and bought it again and changed it again, he even said that the guy bought a ticket in somebody's name. And we're asking the IATA people whether that is possible. The response coming in so far is quite negative. But we want them to write formally to us that it is not possible for somebody to use. So we've written to IATA to the Attorney General in Ghana says that somebody bought somebody's life. Is it possible? So after he had such painstaking investigation that delivered so much fact, the Attorney General thought that it was better to first do a press conference before he charges the accused person. He hasn't charged the accused person. Today, as I speak, he has still not charged the accused person. Having all this gamut of significant information pointing to the committal of an offense, the Attorney General is yet to charge Mr. Adu Boahen. Anyway, then came Okatakyie, who has become counsel for the accused person. And here is what he says. On Thursday, the 20th of March, 2025, Mr. Okatakyie Adu Boahen arrived at the Kotoka International Airport on a British Airways flight from the United Kingdom. It is totally false that he flew economy class to disguise himself as Attorney General was strenuously projecting it to be. Our client was in the business class, a fact which is easily verifiable. It begets belief. Did the Attorney General say that the guy was flying in economy class to obscure his identity? But again, it's so easy. Just take the boarding pass. It's so easy to verify this. Anyway, it begs belief that a criminal should be audacious enough to fly out of the jurisdiction through the Kotoka International Airport, a security area, and return on his own free will to Accra while the criminal routes of the Togo and the Ivory Coast borders are safe. Options available. Okay, let me jump to the next one. On his arrival at the airport, Mr. Adu Boahen reclined at the commercially important persons lounge. A ruse was created that there was immigration issues with his passport and he was wanted at the open place where the passengers of all aircrafts landing at Kotoka International Airport check out. Our law-abiding clients got into the open space only to be handcuffed for public ridicule and ferried to Yoko cells where he is still languishing. The next day, Friday, the 21st of March, 2025, his wife walked to the premises of Yoko to find out how her husband was doing, and she was immediately arrested. Rehearsed criminals do not voluntarily go to the place of the arrest. They run away and become fugitives from justice. Again, when the undertaking is persecution, it is easy to confuse decent and well-cultured Ghanaians from common criminals. As at today, Okatakyie says, Angela has been incarcerated by Yoko on the account of what the Attorney General is using to contaminate our clients in the press and unprofessionally expose them to public opprobrium. It is difficult to come to terms with the fact that the Attorney General is comfortable with the press where there is no proof beyond reasonable doubt. The Attorney General has become the press persecutor of our clients, a judge in his own court, while simultaneously asserting that he is still investigating the case. This is counterintuitive. We do not believe a change of government through constitutional means should degenerate into a reset version of full rule of law in which the press is fed with a pathetic, one-sided, and untested position by the leader of the bar. This unmitigated prejudice with defamatory consequences will be prosecuted in the appropriate forum. We are shocked that at the press conference, the Attorney General was even entertaining himself with issues of plea bargaining when the statements of the suspect are yet to be taken. It was even laughable that the ages of Angela was lost on the Attorney General, given the fact that Yoko has seized her British passport, which obviously had her biodata. Kwabena became the Deputy Director of the National Signals Bureau in 2016 during the NDC time in government. The MPP in power did not jettison his competence and vast experience in the field. Kwabena had been doing business well before he was appointed by the MPP government to the high office of director. I was very much surprised this morning when our clients were denied the right to counsel by Yoko with a reset constitution that I could not have the confidentiality of talking to my clients and giving them the appropriate legal advice prior to interrogation unless an official of Yoko listens to the lawyer-client's solemn engagement. This reset rule of law defies my modest 31 years of legal practice. In today's Ghana, says Okatakyie, the Attorney General is acutely aware he has violated the rights of our clients relating to not more than 48-hour incarceration, constitutional prescription, and tells the whole world that he can play with the bail issues by releasing our clients and re-arresting them. Well, so that's what happened. They said Kwabena Adu Boahen has stolen, he's done this, he's done that. They are still not charged him. Laura, about 4 years, I'm going to rush to him now. But before then, this is an article which we have verified and would like to show it to you. It's written by PK Sapon, and he's writing and whispering from the corridors of a thinking place. Okay, so this is it. PK Sapon says, Kwabena Adu Boahen is not a politician. Dominic Ayini should stop misinforming the public. Kwabena Adu Boahen owns Glofet, a multi-million-dollar company and one of the biggest, if not the biggest, fertilizer company in West Africa. The Attorney General and Minister of Justice, Dr. Ayini, during his press conference to itemize the cases involving some individuals his office has investigated, created the impression that Kwabena Adu Boahen of Signals Bureau, appointee of Akufo Addo, is an MPP member who has acquired wealth and property that defy logic. It is hereby stated that Kwabena Adu Boahen is not and has never been a member of the New Patriotic Party. He is not a politician and has always been a businessman. He is not an MPP NDC matter. It is imperative that these facts are made available to the public about him. Kwabena is the owner of Glofed, a multi-million-dollar company and one of the biggest, if not the biggest, fertilizer company in West Africa, which owns the biggest fertilizer blending setup in Ghana. This entity has loans from banks, including the ECOWAS Development Bank, which it services diligently. Glofed did many business with Cocoa Board when Dr. Stephen Opuni was the chief executive officer of the entity. He and his wife, Angela Ej Boateng, owned several other successful businesses in and outside Ghana. He has been owning businesses long before 2017. It is important to point out that Kwabena has been working at Signals since 2007. He was a public servant under President Mahama, serving as deputy director. He rose through the ranks and became director when the MPP came into office. He owns properties running into several millions of dollars. He has been owning many expensive cars, including Ferraris, G-Wagons, Range Rovers, and others before 2017. Dr. Ayini should stop creating the impression that the gentleman and his wife acquired all these properties and built these businesses when he became director of Signals Bureau. This ugly haste of making this a partisan case is not only reprehensible but mischievous. If he has done anything wrong, he should be put before court. If he has done something against the state, he should charge him and stop linking him to the MPP. It is quite perplexing that Kwabena Adu Boahen has not been charged by the Attorney General yet. He is being persecuted in the media. The nauseating habit of prosecuting people in the public domain when they have not been sent to court must end. This is not how our laws work. Dr. Dominic Ayini should stop hiding the fact that Adu Boahen owns properties and businesses long before he became director of the Signals Bureau. If these facts are not available to him, then his investigators are incompetent. Now, we did a little bit of check on the company called Growfair, and I'll show you what we found on their website. They are a fertilizer manufacturing company, and they are quite wealthy, as it says. What is Growfair? Here it is. Growfair Limited is a wholly owned Ghanaian fertilizer blending company in Ghana, having the largest blending factory in terms of output capacity, producing 48,000 bags, 50 kilograms per day. Viewers, you can calculate how long he's had Glofet and how much he could make from there. Glofet focuses on improving crop production and ensuring food security through excellent yields by providing environmentally friendly, affordable, and quality fertilizers to farmers in Ghana and across the continent of Africa. This is a news story in 2019 where Ghanaian company Glofet establishes a 4.5 million fertilizer factory at Esuboi. The company sent $4.5 million and invested it in Esuboi. $4.5 million. That's some money, isn't it? That's huge money. $4.5 million. He invested it in Esuboi. Now, these are some of the things. Glofed launches Ghana's largest fertilizer producing company, and here it is again. I think I can see Dr. Baumia in there. The Glofed launches, viewers, listen, Ghana's largest fertilizer producing company. Remember, Ghana is the second largest producer of cocoa in the world. And so any company in Ghana that is the largest fertilizer processing company in Ghana, has a lot of business through Cocoa Board, and that's why it's not surprising that the company was working with Cocoa Board. All of these facts are available, but these facts were not showed at the press conference. Lord Chief Justice's purported petition. This will not be the first time a petition is coming to the president for the removal of the Chief Justice. This one is particularly worrying because of the undertones. Now, the story came in just as we were coming to press. So tonight we'll not be able to do a lot, but Thursday we'll bring you so much detail about what we know about the moves, the actions, the shenanigans, everything that is being done within the courts of some of the members of the NDC. We know that there are some of the members of the NDC who find this intention to remove Chief Justices completely preposterous. And they are also sounding their voice to President Mahama. But there's a lot inside to share with you. Now, the petition that has gone to President Mahama is not completely disclosed in Felix Kwachio Fosu's document. But he just says that there are 3 petitions. So let's just quickly take you to the constitutional provision that perhaps will be used. This is the petition here. This is the document from Felix Kwachio Fosu. It's today, Tuesday, 25th March. President Mahama consults with the Council of State on 3 petitions for the removal of the Chief Justice. President Mahama, it says, has received 3 petitions from various persons seeking the removal of the Chief Justice. The President has forwarded the 3 petitions to the Council of State to commence the consultation process mandated by Article 146 of the 1992 Constitution. I believe that's what it is. Now let's get to Article 146 and see what the provision provides. Article 146, removal of Chief Justice of the Superior Courts, removal of justices of the Superior Court and chairman of regional tribunals. It says, 1461, a justice of the Superior Court or a chairman of a regional tribunal shall not be removed from office except for stated misbehavior or incompetence on grounds of inability to perform the functions of his office arising out of infirmity or body of mind. 6 says, where the petition is for the removal of the Chief Justice, which is what we are currently dealing with, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. 7, the committee appointed under Clause 6 of this article shall inquire into the petition and recommend to the President whether the Chief Justice ought to be removed from office. 8, and this is the important one, all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other expert of his choice. 9, the President shall, in each case, act in accordance with the recommendations of the committee. This is very interesting, and now we're going to give you the history of this provision of the 1992 Constitution and show you the philosophy that was behind it. We'll come to that in a minute. Now, these are the people who are going to be very important at the Council of State in dealing with the petition. Now, why do we say they are important? Because Sophia Akuffo here, we understand, chairs the Judicial Committee of the Council of State. Now, this is a judicial document forwarded from the President's office to the Council of State. In those circumstances, it will most likely go to the Judicial Committee of the Council of State. And there, Sophia Akuffo is chair. So she would have a lot to do with this petition. Also is her Lordship Justice Adinira. I think she's also Sophia Agency. I can't remember her first name. Justice Adinira, former Supreme Court judge, is also on that committee. So these two ladies are going to be very, very important in making the decision as to whether the president, as to whether a prima facie case has been made or not. Now, the letter from Ofosu-Kwakye is not clear. It doesn't say the word prima facie. It's not too clear whether the Council of State is invited to make a prima facie case or that a prima facie case has already been made by the president himself and is forwarded to the Council of State. Because the law says the president in consultation with the Council of State. We are not sure. The law didn't say what level of consultation, whether the Council of State should assist the president to make the prima facie case or whether that case the Attorney General assists the president to do so. We're still learning, and we'll find out what these details are. But these are the important, two important women and one man who are going to make this decision either to the left or to the right. The Honorable Do Ajaho, I'm not done, can I have? The Honorable Do Ajaho, former Speaker of Parliament and former MP for Aveno Ave, many years ago he was the Chief Whip of the NDC, is the Chairman of the Council of State. And these three persons, two ladies and one man, are going to be very instrumental in making the decision. Now, Sophia Akuffo herself has a bit of history with this because here is an article here. It is November 2018, and it says, remove incompetent Sophia Akuffo as Chief Justice, Mensa Thompson. A petition was sent to President Akufo-Addo that Sophia Akuffo had engaged in some land, cantonment land, Laboni land, something, and therefore they were asking for her removal. So Sophia Akuffo went through that process and she survived because as far as President Akufo-Addo was concerned, it was not substantive enough to grant a prima facie, so he dismissed the petition. Also here, Akufo-Addo petitioned to remove incompetent Chief Justice, and that was also in 2018. So Sophia Akuffo herself survived at least two petitions against her for her removal, which Akufo-Addo thought was completely flimsy, preposterous, and out of 10. Now she would have a very important decision to make about the Supreme Court that she left behind, now led by Gertrude Tokonu. Sophia will have a very important decision to make as to whether Gertrude Tokonu, the petitions that have come, those three petitions. Now, on the next edition of our program, we're going to, we think we know at least one of the petitioners. We think we know one petitioner. And we're going to give you the history of the petitioner and his machinations within the court system, particularly the Superior Court of Judicature, the High Court, the Court of Appeal, and the Supreme Court. We're going to tell you a lot, a whole lot, because we had heard about the petitions that were on President Mohammed's desk last week. So here we had been preparing our research in case the petition comes. What are we going to do? We were just taken by surprise this evening. We didn't know that it was going to come today, but we had heard last week that there was one petition before the president. So that will be dealt with in extenso, as it were. Now, let's get back to the constitutional provision. And I want to talk about these two men. I just have 2 more minutes to do the story and I'm out. Now, this is Professor Kwame Nahoy, and this is Mr. Chachuchi Kata, but he's also a professor because he's quite learned. Now, these two men were responsible largely for drafting the 1992 Constitution. I think they did an excellent job. Now, they both had responsibility. Mr. Chikata, I guess, had more responsibility because it was Mr. Chikata's responsibility to deliver a constitution that will be palatable to the military junta, to aid the decision by Rawlings to transfer himself from a military ruler to a civilian ruler. In the circumstances, Mr. Chikata's job was very difficult, and he discharged it with a distinction. What he did, and that is why we are shouting about constitutional amendment, because the Constitution has served that purpose of making it look like the authority of a military junta in the executive, so that a military man who wants all the powers allocated to him will find the constitutional process palatable and join it so that we can have a democracy. So they did a good job, didn't they? They convinced the military strongman, J.J. Rawlings, on the armored car holding an AK-47 to drop the AK-47, jump off the armored car, wear a suit and a tie, and sit in the Land Cruiser and go to Independence Square, stand without taking a salute and watch the parade without being military, because the powers that he wielded as a military officer, as a military ruler, were the same powers that the Constitution granted him. In those circumstances, we believe that let's look at the provisions. The provisions of Article 146 were guided in a certain way. It was intended so that when the Constitution takes effect, hopefully with Rawlings ruling, and he was unhappy with some high-profile public official over whom the NDC and the military did not have control towards his appointment, either as a Supreme Court judge, as a justice of the Superior Court of Judicature, or as a public official, regional tribunal head, electoral commissioner, all of those things, that if the military junta were unhappy with some appointment that had been made on their blind side because of the circumstances of the time, Article 146 will be available to be able to get them removed by impeachment. So if you look at Article 146, it is such that the real decision-making part of Article 146 is whether or not there's a prima facie case. If a prima facie case is achieved, the accused person usually does not survive. And he does not survive because of Clause 8 thereof. It says, all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer of an expert. Now, why are these provisions being held in camera? Now, in camera, viewers, means that it is held in secret. There's no media. There can be no coverage. You cannot apply for the record. I don't even think that RTI will work, because RTI, that's the right to information, is an act of parliament. And an act of parliament is inferior to the constitutions of the provision, the provisions of the Constitution, so that an act of parliament cannot override Article 146(8), which is directly prescribing an in-camera hearing. Now, the reason why it is in-camera, as we fathom, is because the military people did not want a situation where they needed a judge removed, a Supreme Court judge removed, a Court of Appeal judge removed, and then the general public will get wind of what questions were asked him and why he was removed. So they say that all such proceedings will be held in camera. So if you're accused of something, you go in camera, and then the report comes. And you see, at the end here, it says that the president shall, that is 9, the president shall in each case act in accordance with the recommendations of the committee. That's quite serious. So the president doesn't have a view on the matter. So they're trying to sort of insulate the president from the processes, but those processes would have been completely controlled by the government of the day. So let's wait and watch this space. But in our next edition, we'll come with some very detailed analysis of why we are where we are with the current Chief Justice. And we all remember Professor Mills, may he rest in peace. And he said in his time, when he became president, there was a lot of pressure on him for this process to be used to remove the learned Chief Justice of the day at the time, Georgina Theodora Wood. Professor Mills stood his ground that he was never going to accept something like that. And he told friends of his that he's a law professor, he's a law-abiding citizen. What is the point about trying to remove a Chief Justice because when you're in the position, you claim that her posturing was wrong? Professor Mills stood and said that I cannot do that. And then he told the Chief Justice, and then at a state function, he invited the Chief Justice for a dance, so that my friends, may he rest in peace, also Alhaji Bature, who were calling for the blood of the Chief Justice, they will see that the president has a very cordial relationship with the Lord Chief Justice. And Georgina would not serve this country well. She served this country absolutely well. So that was the spirit of Professor Mills. And that's what he did in 2009. And I'm not so sure why anytime the NDC comes to power, there's this clamor for remove the Chief Justice, remove the Chief Justice. It's happened in Professor Mills' time. I do also remember that during the Professor Mills' time, President John Dramani Mahama, who was the vice president, was very much against this thing about people wanting to remove Georgina Wood. I remember that he was one of the voices of conscience in the castle over this Georgina Wood matter. I remember that clearly. I've been a news reporter forever, so I was already a news reporter at the time. So I remember that. But let's see how these things shape up, and let's see if time changes people or if it doesn't change people. We'll find out. But because of this, I'm putting up this NDC rally song because Professor Mills' name is mentioned in it. This looks like very, very dangerous times for the sustenance of our democracy. Tonight, we have a big program on the Attorney General's press conference. And by the time we finish, you will see that it is not complicated if anyone suspects that these are dangerous times for the sustainability of the democratic principles, for the sustainability of the law, rule of law, and for the sustainability of law and order in this Ghana and under this constitution. Let's hope that it is not what we think it is. The Learned Attorney General's press conference over Kwabena Adu Boahen, and I must say that on a very personal note, I was very, very disappointed. I was very embarrassed, and I was unhappy with what happened because Kwabena Adu Boahen, I know him well. I think I can vouch for some significant level of integrity of him. He sat next to me at the NCA board, and everybody on the NCA board remembers Kwabena is a very intelligent electrical engineer. So when I heard the stories, I first felt, this one. But as time is going on, you see that things are unraveling, and we are beginning to get to the bottom of the matter, and we are beginning to see whether somebody was stealing a public show or whether there's real substance to a criminal allegation. We're going to get to that in sufficient detail tonight. But just suffice it to say that the story is drawing MPP and NDC, and this is an NDC versus MPP story. But it's funny if you look at it as MPP and NDC story, because if you go behind the curtain and you observe the processes, you will find that Kwabena Adu Boahen here is very, very close to John Dramani Mahama. Kwabena Adu Boahen, I'm not suggesting is an NDC person. No, I'm not, far from that. And I'm not suggesting he's an MPP person, far from that. He's a distinguished public servant who does his work as national security. By the time MPP came to power, he was already a deputy director at national security. He was promoted because of his sheer intelligence. I mean, if anybody who has engaged Kwabena Adu Boahen will say that he's a very intelligent man, but put that aside. So Kwabena here is a deacon of the Assemblies of God Church. You know, when I was, okay, I won't say that, leave that. Kwabena is a deacon of the Assemblies of God Church. The same Assemblies of God Church, the same assembly of President John Dramani Mahama. In fact, it is said that sometimes the two of them can co-chair some of the committees in the church. And who is the pastor of the church? Dr. Wengam, the favorite of many, I mean, I think the all-time favorite radio pastor in Ghana, all-time favorite radio pastor in Ghana is Pastor Wengam. Pastor Wengam is the pastor of both John Mahama and Kwabena Adu Boahen. Both of them are quite close. Now, Reverend Esio Mensah here also has a story in the conversation because Reverend Esio Mensah has a relationship with John Dramani Mahama, and which relationship with John Dramani Mahama also translates to his raising of Kwabena Adu Boahen. So as far as Kwabena Adu Boahen is concerned, John Mahama, President Mahama's home, is also his home. And he doesn't shy away from frequenting President Mahama's home as often as he can. He's very well known to the family and very well known to the First Lady. This is the backstory that we'll be bringing to you after we have done the legal analysis tonight. You can't miss that. Father Wengam, good evening. How are you? And people have been sending me videos of Pastor Wengam's mother's funeral, where Kwabena Adu Boahen was the main MC and President Mahama was a big part of the whole event. Everyone knows Father Wengam's relationship with President John Dramani Mahama, but Father Wengam has the same relationship with Kwabena Adu Boahen. And between Kwabena Adu Boahen, John Mahama, Father Wengam, Reverend Esio Mensah, First Lady Lordina Mahama, they are all very, very close on the religious platform. Good evening.
Good evening.
The Ghana Bar Association has news in the news today. The communications director at the presidency says 3 petitions for the removal of the Lord Chief Justice have been forwarded to the Council of State. What will be the feeling among the barristers?
In my humble opinion, I don't think that the constitutional provision regarding the removal of the CJ was included in the Constitution in vain. I think was included in the Constitution
in vain.
Mm-hmm.
Where it says for the Chief Justice.
It envisages the possibility or some circumstance arising requiring the removal of the Chief Justice.
Yeah.
And so I wouldn't be surprised if anybody, puts forward such a petition, because it is expected that somebody may trigger that provision. The question, however, is whether it satisfies the procedure set down by the Constitution. Because, you mentioned the case of a J. Cho. The Constitution also envisages the abuse of such a provision. And so has ensured that, it won't be triggered just by the mere feeling of it by anybody, or just by the person perceiving, merely that the CJ, ought to be removed. And so the Constitution has got its own procedure. And so when you look at the case of Ejiochum, for instance, you will discover that the president at the time, President John Agyekum Kufuor, in consultation with the Council of State, had set up a committee to remove the Chief Justice at the time, Justice Aban, because Mr. Bright Akwete, a very senior lawyer, had petitioned President Kufuor for the removal of Justice Aban, saying that he had not handled some disciplinary matters involving some judges properly. And for him, that constituted a ground for the removal of the CJ at the time. So he sent a petition to the president. When he did, then Mr. Frank Ejiochum, who at the time used to work for the Statesman, also went to the Supreme Court with Nana Asante Bedi as his lawyer and Nana's father leading Nana at the Supreme Court, saying that, this provision, the president ought to have established a prima facie case, right? The essence or the philosophy behind the establishment of a prima facie case is to ensure that, just as I said, it's not a provision that can be triggered merely because somebody feels or perceives, on some basis or flimsy basis that the CJ should be removed. And so that position has been established. Now, when you look at what has been brought out, to some extent, it doesn't say whether or not the president had previously established a prima facie case. Because when you look at the case of Ejiochum, the Supreme Court dismissed the case on the basis that there ought to have been established a prima facie case before the subsequent consultation with the Chief Justice to constitute the committee of inquiry, or involving 2 justices of the Supreme Court, right, and then 3 other persons who are not parliamentarians, who are not lawyers.
Yeah. So what Ofosu-Kwakye says now is that the petition has been forwarded to the Council of State. What does it mean? Has the prima facie matter been decided and determined,
it is silent,
or is the Council of State going to do it?
It is silent on it. It is silent on it. And all it says is that the president is in consultation with the Council of State in respect of 3 petitions.
But is it the Council of State he consults with for the prima facie, or is the Attorney
General? It is
the
president that establishes the prima facie.
By himself?
By himself. You see, when you look at...
He's not directed to take advice from any particular place.
When you look at Article 146, you have 2 types of proceedings that possibly can take place under Article 146. You have the proceedings in respect of justices of our Superior Court and Regional Tribunal. And then you have the proceedings in respect of the Chief Justice.
That's what we are talking about now.
Yes. When you look at the proceedings in respect of the justices of our Superior Court, right, it says that when the president receives a petition, he will forward the petition to the Chief Justice, who will establish a prima facie case. And then when a prima facie case is established, right, a committee will be put together. That committee will now inquire into the merits of the petition. But when you come to that of the Chief Justice, the Constitution was silent on whether or not a prima facie case will have to be established. The Constitution was silent. So in the Ejiochum matter, the Supreme Court, right, said that it cannot be that a prima facie case will be established in the case of the Superior Court judges, but not in the case of the Chief Justice. Because in any event, the Chief Justice is a judge of the Superior Court before being a Chief Justice. And so there ought to be a prima facie case being established. more importantly too, to also protect the Chief Justice, because, Paul, it will unsettle any Chief Justice. If today you hear that a petition has been sent against me, tomorrow you hear that a petition is pending against me, it will unsettle anybody. It will take somebody with a very thick skin to survive that psychologically. And so it's important to protect that office by ensuring that not every petition that comes that we act on. And so there must be the establishment of a prima facie case. And so the Supreme Court established that but as a matter of principle, which is now the position of the law. Now, in this petition which has come out, right, it is silent whether the president had previously established that indeed a prima facie case has been made.
But if the president hasn't and he does not intend to, would he be out of law?
That would be unconstitutional.
How? Because you are saying that it's silent on it.
Because the Supreme Court has by way of interpretation, right, included the provision or the requirement for the establishment of a prima facie case.
So that case law has now become
the law.
Established procedure.
It's the law, yes.
So the president must establish it. But should he not establish it before he transfers it?
He should.
So should we not assume that he has established it?
We can't make assumptions.
Yeah, but does he have to tell us that he established it?
Paul, in law, you don't make assumptions. You see?
Yeah, but does he have to tell us? Could it be in the letter? Letter that he sent to the Council of State, could it be said that from His Excellency the President to the Council of State, I, President John Dramani, having established a prima facie case on these three petitions, now do hereby, pursuant to Article 146, forward it to you. Thank you very much.
Okay. So
could he not say that to the letter?
He can, but let me share something with you. According to the Constitution, the proceedings ought to be in camera.
The real proceedings?
Yes, including
this one?
Yes, we don't have to know.
Yeah, but Akufo-Addo has said in the case of other Chief Justices that I did not establish a prima facie, my petition is dismissed.
Because he had made a decision on it. Because President Akufo-Addo at that point had made a decision on the matter. And
so you are saying that once the president makes a decision one way or the other, he needs to tell us?
Yes, so the proceedings had truncated.
Yes, he dismissed it, yes.
So you see, when you look at the case of Anas, when the Anas petition when the case of Anas and the judges matter came up, there was a challenge by Justice Derry at the Supreme Court saying that the proceedings ought to have been in camera, and it includes, right, first and foremost, the petition which commences the proceedings. Secondly, the determination of whether there is a prima facie case.
That all should be in camera.
All should be in camera. And so nothing should come out. The Supreme Court agreed with him and said that, yes, we agree with you. However, the breach does not void the process, right? But in a J2, the Supreme Court said no, right? Even though there ought to have been a prima facie, yes, there ought to have been a prima facie determination. Because there was no prima facie determination, it is unconstitutional. And so that is the difference. Here, the Supreme Court has already determined that we agree that it ought to be in camera. The question is it in camera? By this communication, are we going to say that the proceedings is not in camera?
No, but the communication doesn't affect the fact that it's in camera. Communication is just telling us that the president has received the petition.
So it doesn't talk about the petition?
No, it won't.
It doesn't also talk about whether or not the president has also already established a prima facie case?
All that they are assuming is in camera.
That's right. And so it may well be that the president has already established a prima facie case. We don't know.
It is looking like that. Because he's transferred it from one desk to the other.
But at this point, Paul, I don't want to make assumptions.
No, wait. It goes to the Council of State. Comes back to the president?
No, it doesn't come back.
They set up the committee?
That's right. They set up.
The Council of State set up the committee?
They set up the committee in consultation. The president sets up the committee in consultation with the Council of State.
So maybe that's what he's doing with this letter.
Yes. But I am saying that because the letter doesn't disclose, right, the facts. One, the petition, the name of the petitioner, whether a prima facie case.
It's to Or the communication to...
If the communication had done that, would have infringed upon the Constitution.
Absolutely. So the communication did the right thing.
It did the right thing.
And I'm asking you that, are barristers tonight going to be worried that the president may have made the prima facie position and that he sent it to the Council of State and they are going to soon announce the constitution of the panel?
Is
one Supreme Court or two Supreme Court judges?
I'll tell you, I am worried.
During the pendency of the process, is the Chief Justice still Chief Justice?
The president can suspend him, suspend the Chief Justice.
During the pendency?
Yes.
It's in the law?
Yes. Article 146, Clause 10.
Oh, in the same Article 146?
146.
The 10 says what?
The 10, the president was in consultation with the Council of State.
May decide to, by signing a warrant, to suspend the Chief Justice. During the pendency of...
Yes. It appears to
in
be...
that case, who will do the work of the Chief Justice?
The most senior Supreme Court judge.
Who is the one there now?
Justice Bafuboni.
This is frightening.
Very frightening. Paul, this from yesterday, or for some time now, let me say this. I've been pondering on a lot of things. I think that to be the president of a country, you need a big heart. You should be like a mother who is ready to overlook so many things. Especially in the case of President Mahama. This is his final term, a second opportunity by God to make an impact and leave a lasting legacy. I would plead with him to choose the path President Kufuor chose from the year 2001. You see, when President Kufuor came to office, there was also pressure on him, not just to prosecute people, but to also visit vengeance on President Rawlings and his administration.
Boot for boot.
Boot for boot. The lives that were lost,
businesses that were lost,
that were collapsed.
They wanted, it was true, they really wanted Kufuor to crack the whip.
There was a lot of pressure on him. I remember growing up in Kumasi, where some people in the business community, their relatives had suffered, imprisonment, abuse of power, and so on and so forth. They have become victims of it. A lot of people looked forward to the change of power and were hoping that there will be consequence.
The Rawlings will be dealt with.
It will be dealt with. President Kufuor takes over power and says that, look, enough is enough. Let's set up a National Reconciliation Commission, right? And let's move forward as a nation. And only God knows, we can remember the blessings we received as a country. I want to plead with President Mahama that, look, we cannot develop as a country in this manner. If you touch the Chief Justice today, tomorrow, if we are unlucky, and we have a president who is also vindictive and also receives pressure from his party people, we are going to see the same. It's going to be like how the Flagstaff House changes name with the change of a president.
Yeah, President Mahama hasn't changed it.
Yes.
He's kept it.
But I'm saying that historically has been the problem we've had. And so I am saying that with the greatest of respect and humility to the president, we know him previously to be a man of big heart and had boundaries.
Political moderate.
Political moderate. We are praying, I'm hoping that he's not going to succumb to the pressure. It is going to affect the building of this country and it's going to set us back.
But what could, what's the Chief Justice's name again?
Gertrude Torkornoo.
Gertrude Torkornoo. What could Gertrude Torkornoo have done against the state, against the office of the Chief Justice, against the image of the Supreme Court that can warrant a petition? I'm shocked.
I don't know the facts.
Yeah, but we will never get to know.
Yeah, but you see, Paul, the NDC has always taken the view that the judiciary is unfairly structured against them in terms of composition. They've always taken the view.
I have heard Fosu Kwakye say that.
Exactly. And so perhaps they think that this is the way to balance it.
Balance it by bringing in a different Chief Justice. And what will he do? Bring new Supreme Court judges?
Well, you know how the Supreme Court, the influence of the Supreme Court, right, and that of the Chief Justice. And so if you have an acting Chief Justice or a new Chief Justice, there is going to be empaneling, right? He's going to have this constitutional duty of empaneling. That would mean that the NDC probably thinks that in empaneling judges at the Supreme Court, there is going to be a balance for them, or a panel that will be favorable to them.
Let's switch to the Attorney General because it's 11 o'clock now. But just before then, if there's a petition right now going to the President for a removal of a Supreme Court judge, what is he required to do? Send it to the Chief Justice?
He will send it to the Chief Justice for the Chief Justice to determine whether there's a prima facie case.
That could be interesting.
Yes.
That could be very interesting.
Yes.
But can the President decide to ignore the petition?
If he determines that, I mean, we wouldn't know if he has ignored it. He may ignore it and we might not know.
No, once we know that a petition has gone and he hasn't forwarded it to the Chief Justice, he's ignored it.
He's ignored it. But I'm saying that you wouldn't know, I wouldn't know. In the past, we have heard commentaries from the president.
From the petitioners that they have sent a petition.
Exactly. And so, I mean, if that can be done quietly, then we might not know.
The Attorney General held a press conference yesterday and you have some views about it. What did you make of it?
Well, again, you know, yesterday, the person I saw very respectfully wasn't my good friend and big brother, Dr. Dominic Ayeni, who is also a moderate. Yesterday, he was different, and that he conceded that there's a lot of pressure on him to prosecute. So you could tell that he's acting under pressure. Paul, I concede that, you know, where a person holds public office, he has a duty to submit himself to accountability where necessary. And so it's very important for me to state on record that, Paul, I sitting here will never, ever defend anybody who there is against whom there is stark evidence of corruption. But it's also very important that a balance is struck, right? A balance is struck in making sure that the rights of that person is also protected, right? So in speaking on this matter, people have said, why are you defending Adu Boahen? Why are you defending this person? No, we are interested in making sure that there's a fair balance. There's a fair balance in terms of the information being given to the public, and then the protection of the person's reputation, right? In fact, the person's name ultimately. So what happened yesterday, that for me is where I disagree with my learned senior Dr. Ayeni. I think that yesterday he stood in front of us, couldn't even say that Adu Boahen has been charged. By the way, Adu Boahen is not a politician, he's a civil servant. And so when I speak on this matter, it's not as if I'm defending a member of my party. I've never met him anywhere, but it's a matter of principle that we need to make sure that people are not tried in the media. Oh, we've, for instance, seen several press conferences by the Office of the Special Prosecutor. To my surprise, I get to know that after the many press conferences, he only has 3 cases that is being prosecuted.
In court?
In court.
Which one?
The Republic versus Ajeni Mboateng Ejeyi, who is not a politician. The Republic versus Sumaila Abdul Rahman. The Republic versus Alexander Kwabena Safo Kantanka. Just 3 cases after the many press conferences. And so the point we are making is that we need to be careful. For instance, we had several press conferences about somebody like Madam Cecilia Adapa by the Office of the Special Prosecutor. She was tried in the media, only for the Special Prosecutor to say that the case is not within his remit. What he simply meant was that it was not a corruption or corruption-related case, because that is what the Office of the Special Prosecutor has power to deal with. However, this woman had been bastardized in the media, right, for being corrupt. Meanwhile, the Special Prosecutor had come to the conclusion that there was no prima facie case against her in terms of corruption or corruption-related offense. And so, going by this history, I get worried when people are tried in the media. Names are very important. We may well end up with the person not being tried, after all, going by the antecedent of the Special Prosecutor. We may well end up going to court and the person being acquitted and discharged. And so, if that happens, what would have happened already? You'd have destroyed the person in the media. The person has family, the person has
Justice
children.
Semsai, speaking on CTFM this evening, was strenuously defended the position that what Dominic did was not a public trial, that he was not trying anybody in the media. He defended it. I don't know whether, producer, do you have that sound? Okay, they don't have it. So CTFM with Umaru Sanda, strenuously defended. Let me take text messages, Lawyer J. Bafo, and then I'll come back to you for the wrap-up. Because it's 7 minutes past 11 o'clock. And I begin with Kobe first. Fatih, sorry, you wanted to start. This time it's men's first before ladies. Kobe, you start.
Our February starts by saying, your illumination to establish prima facie case for the removal of the Supreme Court judge holds the same for the Chief Justice. The committee from the Judicial Service to determine whether the case is substantial enough for the removal of the CJ. Now, Richmond Kofi Ejipong says, Paul, with the greatest of respect, it's false that the president has to establish the prima facie. The decision in Frank Eje Chum establishes that the Council of State is the body to establish the prima facie case. Afterwards, the president can institute the committee laid down in Clause 6 of Article 146. Thank you. Now, Akpa Tamale says, for me, actually, this is what I always maintain, that NDC is our problem in this country. All the appointees are just going wrong, making allegations, creating impression that they are working, but they should know we know them more than the way and manner they know themselves. You can use propaganda for the good people of this nation to vote for you, and you want to use propaganda to governors. It can never happen. We will not allow that. We will not allow that. No matter how you bring your propaganda, we will continue to expose you, your people. Your people should go and work and stop during press conference. Now, finally, Raymond Inso says, good evening, Brother Paul. The resetting NDC government has no faith in the current court system, so they have decided to take the alleged cases to the public tribunal. This action by the Attorney General is just pure partisan propaganda to discredit the previous NPP government. God bless you, Paul, and your team. Now, what do you have for us, Fatih?
All right, so coming from Mark Prince says, please, can he give us the full citation of the case he mentioned about the removal of the Chief Justice in the era of J.A. Kufuor? Sandy Jr. says, Lawyer Nana J. Bafo, very nice submission, such a great leader. Richmond says, with the greatest of respects, it's false that the president has to establish the prima facie. The decision in Frank J. Chum established that the Council of State is the body to establish the prima facie case. Afterwards, the president can institute the committee laid down in Clause 6 of the Article 146. ABFA says, at this trajectory, if the NDC and John Mahama continues this way, the military should act and kick. Now he comes again to say, like the attention, seeking OSP may without doubt be academically good, but in high office practice. Otu Evans says, I'm really surprised not even a law student will behave like how the AJ is doing now. If you have any evidence against people perceived to have caused some financial loss against the state, why not go to the court so that the law will take it at its own course? And lastly, coming from France, he says, Dominic Ayini in press conference incriminated Paul Adu Boahen. I think he has completely forgotten the very law syllabus he was lecturing at the law school. This same person will, after the NDC has lost run, back to the lecture hall to confuse innocent students. Now back to you, Paul.
The case is Frank J. Chum, and somebody is writing to me to remind Lawyer Bafo there wasn't a petition to remove Aban There was a petition to remove CJ Aqua.
Aqua, sorry.
Yes, Aqua. It was
It's
during the
Aqua,
Kufuor era.
yes. It's Aqua.
What would be your concluding remarks tonight, lawyer?
You see, when you take over power, there will be a lot of pressure on you. But you need to be careful. Unless you are careful, Paul, you will do so many things that will set the nation back, that would, commission scars on the minds of people, which may lead to retributions in the future. And so I am urging the Attorney General that nobody is saying that he should not prosecute corruption cases or cases he suspects of involving corrupt persons, but he should approach it with tact. In fact, yes, there might be public interest in the matter, for which reason he might find the need to update the public. But he ought to create a balance as to what information comes to the public. You don't come to the public and put forward facts that are unverifiable, facts that are yet to be tested in the courts of competent jurisdiction, right? In the manner which suggests a public, not just a public trial, but also a firm conviction of the person, when you know that conviction doesn't lie with you. That really is my final comment.